You are now live and on the air as well.
He is. I just got a note from him. He's trying to get in. There we go. Is that you, Ron?
That's me. Can you hear me okay?
Yeah.
Okay.
All right. I guess it's that time. We can call to meet the special meeting together. We've got a couple of issues. Ron had asked me earlier whether we needed to approve the agenda. Since they're in a special meeting, since the agenda is fixed, and so I guess we can forego that. There are two items on the agenda that
I do have a question about the agenda, DT.
okay.
When you sent the original agenda out, it mentioned any type of pending or potential litigation between the superintendent and the board. But then when you sent out your motion for today, it seemed to differ from the original agenda item. I just want to make sure that we're in compliance with state law, that we're actually going to bring up what's on the agenda for the day.
Okay. Let's see if I can bring them up. The agenda items basically follow what the agenda is. Is there some language you'd like chopped out of it?
No. I just I think the original, and I don't have it in front of me. I'm sorry. I'm in my truck. I tried to get this thing moved to some other time because I knew I was going to be unavailable. So just bear with me just a minute. I'm going to try to find exactly what it is here. But let's see.
There's someone.
No, we lost Tag's video.
Okay.
I see we turned it off because he's probably searching on his phone.
I am. Can you hear me?
Yes.
Okay, sorry. My connection's spotty. I'm not even able to get into my email. It won't load up the emails. But anyway, I just want to make sure, Ronnie, I guess I'll have to defer to you just to ensure, if necessary, we may just have to have DT modify his motion to make sure that it matches the agenda. So,
Are you still there, Tag? I hear you, but I don't see you when you're talking.
I'm here. Hang on. Let me see.
There you go. Got you.
Is that better? Okay.
Yeah. We just got to have both audio and video if that's what we're doing. That's what I want to make sure of.
Ron, you want to read the first item on the motion that I put with the agenda item, so we all understand what we're talking about?
Let me find it here. This is because I think the motions that you said you were going to make about the items.
Yes, I sent a copy out so we could not mess it up in translation.
All right, let me find your motions. Okay, they were reversed. So what is it you want me to do, DT?
Just read the motion, I guess, so we all know what we're talking about.
Well, read the agenda item out loud first, and I just want to make sure DT's first motion matches the agenda item. That's all.
Okay. Got back to my motions. Let me get back to the agenda. I had it printed out, but I got so many emails the last couple of days with this stuff. I thought it'd be easier to look at just the agenda on the computer. There you go. Agenda item number 1 was consider engagement of outside attorney to defend board against legal action by superintendent. He didn't say Billy's name, but by superintendent in the Berrien County Circuit Court. That's what it says.
Okay. Is there pending litigation right now, Ronnie?
Yeah, there are in the litigation that was filed by DT, which is the only litigation that's filed. There are still motions which Billy Ray has filed by his attorney. One is to intervene. That renewed his motion to intervene, so that's against the board, and or will be his claim that he wants to file as part of that action would be against the board. And then he also has his
okay. So
there's also, and I don't know how, we'd have to ask Billy Ray's attorney about it, but he filed the ex parte motion for a restraining order where the judge at least has temporarily put his order in place that kept Billy Ray's issues from coming up. But I don't know, it's hard to tell from the motion itself as to whether he's trying to restrain the board from taking any action until after a due process hearing, so I'm not sure about that. So that could also be a pending thing that's got to be addressed before Judge Alexander. And I think he's got a hearing set for November the 30th, if I understand that's correct. I didn't receive notice of anything, but when I talked to Libby today, she wasn't aware of that either. And I don't know if that's a time that the judge is set to use as far as the merits, or just to try to be a strategic planning. When are we going to do all this? So I've not seen any orders as a result of that. But there are two potential still, in my opinion, actions that be against the board filed by Billy.
all right. I'm sorry. I lost connection there just for a second. Came back in. But Ronnie, this is, I don't know if you remember, and I've been made fun of this, for saying this several times by DT's son, John, but I think I asked you this several times. Are you sure that this is a position that you want to be in? And everybody agreed, you included, that this is a position that you were wanting to take in order to defend the board and the entity of the EPB against some of these potential potential litigation. And now here we are voting on the same thing again. Is this not what you envisioned, your role to be?
The engagements that we've had before were from outside people. This is an inside fight, and it would be very inappropriate, I think, for our attorney who represents us all to be engaged in litigating this.
Well, boy, DT, this is the first time in a long time you and I have agreed on something 100%. This is exactly what I was saying when we had this discussion about Ronnie feeling like he was in a position to be able to do this. And to me, it was a clear conflict of interest. I'm glad we're addressing this at this point because this gives us an opportunity now to kind of move Ronnie out of that precarious position he was in ethically. So, okay, I just want to make sure we're all on the same page for that.
Yeah, let me just say something about that, Tag. When you asked me that question, and I think it's been made fun of. I understand. I've not seen that, but I understand. A lot of people had a lot of fun with it, I guess.
Yeah,
but
right.
In my position, I represent the board. That is, you guys, the majority of you guys. Whatever y'all decide, that's what I got to do. You also we were talking about outside counsel, and it may be the way you and I look at it differently. I don't see the entity, I'm going to call that the business itself, okay, the entity, as a separate unit from the board. The board is the head of that entity and makes all the decisions. My job to protect the entity is to make sure the board doesn't do anything improper that's going to get the entity in question. If they're going to do something, I'm not making a policy decision on behalf of the entity, even if I were to think the board decision might not be, the best position to take for the entity. That's not my call. That you guys call. But if the board wants to take a position, if they do it properly and it's not illegal, then that's how I protect the board as well as the entity itself. But
Yeah, and my argument has always been, Ronnie, that the entity's the one that pays, not the board members. The entity's the one that's subject to damages, not the board members. So, that was my position all along. But if you all feel like that this will solve it, then I'm all for it. I just don't want to have that, that obstacle in front of us if we move forward through litigation. That's all.
Right.
So,
well, it does take me out of that position. I think when it comes to, until the board's able to do something, when you take a position and it's adverse to DT or vice versa, it does put me in a spot when I give both of you advice or answer any questions you got. If somebody doesn't like my answer, they accuse me of being on the other side. It takes me away from that. That's not the way I try to behave, but it does. I think all the emails I've seen from the Kentucky League of Cities lawyers, and I think even in Billy Ray's attorney, Mr. Davenport's communication one time, they all sort of acknowledge I'm sort of in the middle, at least between my board members' disputes.
Right. Yeah. Yeah, that's right. That's right. Okay. Well, I just want to make sure that we see that we're on the same page with that. So I'm sorry. I didn't mean to hijack that. I know we need to move on I've got a couple other questions, but we'll wait till we get into the discussion portion of this thing before we move on.
DT, why don't you, I think we approved the agenda at the last special meeting. We can't do anything about it. You're entitled to call a special meeting and have an agenda. If you don't think it's necessary, I don't know that it's absolutely necessary to approve the agenda in that case. That's part of the policies that y'all did approve, but it's either going to be, we're either going to have a special meeting or not, and that's going to be the agenda item. So if you want to, somebody make a motion to approve it, I think that's not going to hurt.
Okay, we have a motion to approve the agenda on the table.
I'll make that motion.
Have a second?
Second.
Motion made and seconded. All in favor? Say aye.
Aye.
Motion carries. Next is the first item, and that is to consider the engagement of outside counsel to defend the board against legal actions by the superintendent of the Barron County Circuit in the Barron County Circuit Court. And I have sent out a printout of this so as not to miss some of it, which you should have or have seen. And that is, I move to engage the attorney Matt Baker of Bowling Green to represent the GEPB in the Barron County Circuit Court regarding action by superintendent prohibiting the board from executing its purpose of lawful authority in the management of the GEPB. Mr. Froge, that's me, has agreed to engage another attorney to represent himself in the contempt of court charge, and thus the board waives any conflict of interest claims in regard to Mr. Baker's employment. Mr. Baker took over the position of Paul Lawless and was brought up to speed on it all, and then he has not represented me or done anything for me, so I don't think there's a conflict of interest. But anyway, it would be my intention to engage another attorney to represent me in the action on the contempt charge, and that's to keep that separate.
DT, I would add he did enter an appearance on your behalf and asked the judge to set a hearing on all the pending motions not been finally ruled upon, but other than that's he's not appeared in court with you. You're correct about that. But he did file that motion.
He filed a motion to replace Lawless, but he hasn't taken any action on anything from me.
But yet the fact that you have, as you brought him up to speed, per se, from your viewpoint and your viewpoint only, would in itself constitute a conflict. I mean, would it not be customary to send out, you know, a thing for who might be interested in that position and to go through
Lawless was acting on the board's behalf before, and then when Lawless decided to withdraw, Mr. Baker stepped in and spoke with Mr. Lawless and came knowledgeable in everything that was going on, and then filed to represent me.
No, I understand that, DT. What my point in that is that he has been brought up to speed by the person who was your attorney during everything that's been going on, and so he's been brought up to speed on your behalf, not the entire board or the board's interest.
Well, Lawless was hired by the board, I believe.
I'm talking about Baker. Baker, Lawless has been representing you through all this, whoever he was hired by. But I'm saying Mr. Baker has been brought up to speed by him, which would be in his representation of you over the past several months.
Well, and
I'll have to yield
Ronnie,
on
yes,
the propriety.
yeah, I was going to ask Ronnie the same thing. Ronnie, I mean, it's your opinion to this board that DT, having utilized Mr. Baker to enter on his behalf a motion to set a hearing, doesn't constitute a level of participation on his behalf that could potentially cause a conflict of interest with the entire board. Is that right?
Well,
I mean,
no,
because we could potentially have an adversarial relationship between the board and DT, or members of the board and DT. And I just want to ensure that that's not, you know, we're not getting into some murky waters here. If we are, we probably just need to look somewhere else, you know.
Ultimately, that's a question that Mr. Baker's going to have to answer to decide whether he's going to put himself in that spot. We do, as attorneys, have a duty to avoid any even appearance, you know, of a potential conflict. That is all that Mr. Baker has done, is asked the judge to set that hearing. He did enter an appearance on behalf of DT. I don't know if I discussed it with the Kentucky League of Cities, you know, because I talked to them today because we got emails from it, and they didn't necessarily express an opinion about it, but they acknowledged that the potential conflict argument would be there. And I think the board certainly is able to weigh that conflict at this point. And then Mr. Baker's going to have to decide whether he is satisfied with that and feels comfortable enough to move forward representing the board and not DT. Certainly, if the board's actions are adverse to something DT wants to do, then Mr. Baker's duty would be to do what the board requests of him, not what DT requests of him. Because he's representing the board, not DT. Mr. Board, I think, of course, at this point, we got another meeting before the next court action. I haven't.
I'm sorry, Ronnie. I lost connection there. Could you say that one more time?
I said we do have the meeting next week. I haven't talked to Mr. Baker about any of this. I hadn't talked to I couldn't tell you last time I talked to Mr. Baker with it regarding any kind of case, but you know, it may not be a bad idea to have Mr. Baker, if he's able to be present at the next board meeting. You guys don't know him. Well, you may know him. I don't know if you do or not, but you know, to satisfy any questions that you all may have, you know, prior to this vote.
Well, I mean, to me,
that's an option.
To me, on its face, it seems like there's at least an appearance of conflict here. But like you said, that's just me. I'm one member of this board. The majority may feel differently. And then at that point, it's going to be up to Mr. Baker. But I'll go ahead and tell you, for the record, I do see the appearance of a conflict. And I think any reasonable person would probably see the same thing. And Ronnie, I'm not going to put you in a position. I'd like to ask you what you would do if you were presented with this, but I'm not going to put you in that position. I have a feeling I know what your answer would be, but hey, you never know. I think also there's a pretty simple solution to this problem. If my memory serves me correctly, I believe we've all been issued a letter.
We lost you, Tag.
Sorry, y'all, I've lost connection again. We've all been issued a letter from Carrick, which is the attorney that was assigned to us by the Kentucky League of Cities. They stated that they now realize that they are going to start, they've offered that representation to us now in the event of any potential litigation. So I really think, what we're talking about here may be a little superfluous because we already have that representation through the Kentucky League of Cities with Carrick Law Firm. So that's just another thing to think about.
Tag, I talked to Mr. Carrick today. It was my understanding that, in reading that letter, that they will come in, with a reservation of rights. That's after, and if Billy Ray's motion to intervene is successful. Of course, someone's got to defend the motion itself because they're not in there. They did, at least, and I asked them today because there was questions about the deductible and who's paying for these attorneys and so forth. And the initial impression from that letter indicates, well, it's all nothing's going toward the deductible already yet for some of those things. He has indicated to me he's going to go back to the insurance carrier and ask them to possibly reconsider the part as far as any attorney's fees that may be incurred outside of their firm in the way of defending these potential motions, so that they at least get applied toward the deductible, because it eventually, even though they're not in yet, they have attended some of the proceedings, but they've not participated. And I don't know that they're going to participate in Mr. Davenport's and Billy's motions to continue with their intervention as well as the restraining order, even though all of those are ultimately going to have some impact upon the litigation that looks like is coming down the road, that they're for sure have acknowledged, they're going to participate in. So I'm not sure why they're not participating already, but they haven't so far. But I think that,
so they've sort of taken the same position that I'm looking at this here. It seems like that, we are getting in front of potential litigation that's not really even occurred yet. And if we're afraid that litigation is going to occur because of some action that we take as the board, a prudent person would say, maybe we don't need to be taking that action, because if we take that action and we knowingly know that it's going to be, with intent, that it's going to lead to some sort of lawsuit that we need representation on, then all of a sudden that moves it now from just a negligence to a gross negligence level. And, punitive damages come into play at that point. So maybe it's best we don't take the action. Now, I know that's probably going to fall on deaf ears, but, that's my position, that if we're so worried about the superintendent suing the board over action taken against the superintendent, maybe it's wise not to take the action if we can already see that happening. But that's a story for another day.
Right. Well, I understand what you're saying, Dag, but he's already asked to file his complaint against the board. So there's no question, that's coming. So it's not like we're inviting, not like you guys would be inviting it. It's that litigation and that motion is already pending. So someone's got to respond.
The motion to intervene, but that's not the same as pending litigation against the board. It's a much smaller, hurdle that we've got to worry about there. So, that just allows his participation in the potential litigation. It certainly doesn't indicate that there's going to be, litigation that requires the engagement of an attorney. So, that's just my opinion. So,
we are required to have an attorney to answer this to be at the hearing on the 30th. And Mr. Baker has agreed to do that and attend that and represent our interests. And I don't see a conflict of interest in him doing that.
Let me if I could just add one thing, Tag, my comments are really based upon the, not just the generic motion, but the attached intervening complaint that he's wanting to file. So,
Okay.
Okay.
Would it make anybody, would it make everybody feel better if we waited until the next regular scheduled meeting and talked to Mr. Baker? I mean,
Well, I think Glenn, and that's a good idea, Glenn, but I think customarily there's like a process you go through to hire an attorney, like a selection committee, But I mean, I would hope that we would be a little more diligent than just choosing, just who a board member say. I mean, if that's the case, I could say this attorney over here, what makes one any better than the other. You know what I'm saying? But yeah, I think we need to at least speak to Mr. Baker. If not, also send out maybe feelers if there might be another attorney that we could interview as well who might be interested in the position.
I think the time was part of the issue. Is why I was trying to get one, I think, fairly quickly.
Yeah.
Because it's coming up the 30th.
Is that right? Right?
But I mean, like I said, if somebody's interested, can understand the expediency.
Mr. Ray, you have the floor.
Tag is not on the Zoom meeting now, so you all need to stop.
okay. Tag's got to get back on there, DT.
I have no idea. Wait, guess that's the chair's discretion.
Pardon?
I don't know how long we're supposed to wait. I guess that would be up to your discretion, DT.
I'm not sure, Ronnie. Can we proceed with the meeting if someone dropped off?
No, once you start the meeting, the rules say that if you lose video or audio contact, you got to stop the meeting until that's redone, reconnected.
I think they waited a good 10 minutes on me the last meeting. I dropped out, so.
Yeah.
Somebody want to text Tag and see what the situation is?
I already did. I haven't gotten an answer yet. Yeah. Oh, and I mean, part of that too, I mean, DT, just as a courtesy, the next time there's like a special call meeting or something, it'd be good if you could kind of reach out to us, maybe just see if everybody's schedules can sync a little.
I don't want to cut you off, baby, but I don't know if that's considered part of the meeting or not, but I don't know.
Okay, that's cool.
I'm not trying to cut you off. But.
No, that's fine, Ronnie, I understand. I'm sitting here with a killer headache. I'm just trying for us to be expedient.
Tag's getting back on. Step away for just a second. I can still hear.
I think they say that Tag gets back on, I'm gonna step away for something like that. He clearly stepped away.
Well, while we're waiting on him, it gives me a break for just a moment.
was gonna.
Well, that was sick there at the top. I don't know what.
Oh,
I've never seen that before.
but either. Because she was the last talker.
Maybe.
That's weird. Libby said she had already called in and wasn't getting any response. Who's this? I'll see.
Or something. So,
Can you pause for a second since you're pausing?
We're kind of waiting on.
A wall of business.
that's the second or third one.
Oh, yeah, when we first did this, they were coming in like it said, welcome.
Yeah.
Then we hired, he found ingress and egress and got them plugged up.
Chris, who watched it, the shuttle, the launch. Did you watch that?
Mhm.
I don't know, it's just.
I think Suicide was the first stage landing back on the bar.
Yeah, how about that? Right smack down on target.
Yeah, and then that was the time period because it actually blocks the satellite reception. It's kind of,
I noticed
yeah.
that.
That's what people were like, yeah, they're not trying to fool you folks. It's not a magic trick. It's, it actually comes in its trajectory path, but it's blocking the satellite system or the satellite uplink.
I thought maybe just the heat.
Have you seen the Cybertruck?
Oh, yeah.
I think it's so ugly.
I know, I mean, people are so excited about it.
It's,
I wouldn't be caught dead in that thing.
it looks like something from a Terminator movie. People taking the Teslas and getting them now and leaving just driver's seat, run nines.
Did you notice that? That's good. But they were there.
I saw a video of a Model 3, the cheaper one. It had a wreck that's 100 miles. The batteries just went everywhere. On fire. Wildfire.
Everywhere down there.
Somebody. Yeah. Something. This. Libby, our buddy Rob, his little dog died on him. He's pretty tore up.
I know, bless him.
He had that dog for 13 years, I guess.
That has laid him low, though, Glenn. It really has.
That was his son, his first child, you know.
He came in the office the other day, and I said, Rob, I'm so sorry about your dog. You know, I said, I hate that. And he said, yeah. He said, I haven't hardly left my house, you know, but it did.
Yeah.
It crushed him, bless him.
Yeah.
So
Yeah.
he even messaged me. He sent me a message on Messenger.
Yeah.
You know, and I'm like, oh, I'm so sorry. But yeah, bless his heart.
Yeah, I was in that group too. I think that he sent,
I didn't look to see who I was in it.
but then he dropped out. Like he sent the message and then he dropped out of the group. So
I know. But he had the dog cremated.
yeah, that's right. I forgot about that.
He had the dog cremated so that he would have his ashes.
Yeah.
But yeah, he's bless him.
He told me one time, he said, now that dog will eat before I do. And I believe that, you know. He took care of his little dog.
He really did. Yeah, he loved that dog, and he has. He's just been kind of down.
Yeah.
Then we had a resident pass away yesterday, and we've had a rough week. It's been a rough one over there this week. So
Yeah. Billy, has Todd Barber been behaving himself this week?
Are we still muted?
No, we're not.
Okay. I guess, Glenn, we're trying our best not to be around each other.
Yeah.
So I haven't, I did walk by his office once this afternoon and he was in there and he appeared to be behaving.
Okay, well, good.
We're all nervous about one of us getting it and infecting everybody.
Right.
That's why we've got Marlon locked in a room back there.
Yeah.
And then he escaped.
I don't know where Tag's at. He's not answering any texts or anything. I think he's in the middle of nowhere.
He's out about 30 minutes for lunch. Yeah. It ain't no catastrophe. Thank you.
Oh, me. Y'all, I swear, my husband is over here while I'm looking at this computer and he's trying to figure out how I fix my Parmesan crusted chicken. And ooh, if I look like a fool sitting here laughing, it's because of him.
Yes, just for 2021, it's just gonna be a regular old thing.
Okay. I didn't know if they were cashing.
Do we have a predetermined set amount of time that we're going to wait, or what are we doing?
Maybe there's no time in the statute, I guess. It's just ever how long you guys want to do it.
Okay.
Pardon?
I said statutorily, it does not say, it doesn't tell you what to do. It's time-wise. The board. You just have to wait until the broadcast is restored. And how long you're going to wait? Any guidance about that? It doesn't even say reasonable time or anything. It doesn't address how long you wait. So I think that's just up to the discretion of the board. But you know.
Why don't we give it another 10 minutes, and if he doesn't, we presume he's not coming back.
T, I'm gonna mute myself so that y'all don't hear me shuffling papers, but if somebody starts talking, I'll unmute.
We'll yell at you. Or wave. Well, guys, I think we waited about another 10 minutes. I presume Tag's not coming back, so since we can't continue the meeting, we can't adjourn either, so we will just shut it off.
Mr. Chairman, would you like for me to add these agenda items that will be coming out tomorrow for the meeting on Tuesday?
Yeah, that's probably a good idea. We can do that.
DT, can you make arrangements for Mr. Baker to be at the Tuesday night's meeting?
Or what?
Could you make arrangements for?
I'm sure he will do that. I would presume he will do that, yes. I had not talked to him about doing that, but I'm sure he will.
We can just send the Zoom link.
Yeah, I'm sure he will. I'll talk with him about it.
Okay, that might be good.
And we'll just add these items to the agenda. This is one of the downsides of video meetings. If one person goes off, everything stops. And
DT, just be sure you get him that Zoom link so then he can still participate from Bowling Green, so it should be less burdensome for him.
yeah, he could do that. I think he's done that. All right. Can't adjourn, but we can shut her down. Thanks, guys. Good night.
Oh, it's something Eddie was using.